Montauban v. Cumlick. Facts: Montauban, Ondoe and Potencioso, Jr. were candidates for municipal councillor of the municipality of Tuburan, Cebu for the May 14, 2007 elections. Petitioners and other candidates filed a petition for disqualification against respondent with the Cumlick, alleging that respondent had been elected and served 3 consecutive terms as municipal councillor in 1998 to 2001, 2001 to 2004, and 2004 to 2007. Thus, he is proscribed from running for the same position in the 2007 elections, as it would be his 4th consecutive term. Respondent admitted having been elected, but claimed that the service of his 2nd term in 2001 to 2004 was interrupted on January 12, 2004, when he succeeded as Vice Mayor of Tuburan due to the retirement of Vice Mayor Petronilo L. Mendoza. Consequently, he is not disqualified from vying for the position of municipal councillor in the 2007 elections. Petitioners, on the other hand, contended that voluntary renunciation of the office shall not be considered an interruption in the continuity of service for the full term for which the official concerned was elected. The Cumlick denied the petition for disqualification. On appeal, the Cumlick en banc affirmed and ruled that there was no voluntary renunciation of office, but rather, an effective disruption in the full service of his 2nd term as councillor. Issue 1. Respondent's assumption of office as Vice Mayor in January 2004 interrupted his 2001 to 2004 term as municipal councillor. Held yes ratio. In Lanzanita v. Commission on Elections, the court held that the 2 conditions for the application of the disqualification must concur: 1. That the official concerned has been elected for 3 consecutive terms in the same local government post, and 2. That he has fully served 3 consecutive terms. In Borja, Jr. v. Commission on Elections, the court emphasized that the term limit for elective officials must be taken to refer to the right to be elected as well as the right to serve in the same elective position. Thus, for the disqualification to apply, it is not enough that the official has been elected 3 consecutive times, he must also have served 3 consecutive terms in the same position. While it is undisputed that respondent was elected municipal councillor for 3 consecutive terms, the issue lies on whether he is deemed to have fully served his 2nd term in view of his assumption of office as Vice Mayor of Tuburan on January 12, 2004. Succession in local government offices is by operation of law. Section 44 of Republic Act No. 7160, otherwise known as the Local Government Code, provides that if a permanent vacancy occurs in the office of the Vice Mayor, the highest-ranking Sangguniang member shall become Vice Mayor. In this case, a permanent vacancy occurred in the office of the Vice Mayor due to the retirement of Vice Mayor Mendoza. Respondent, being the highest-ranking municipal councillor, succeeded him in accordance with law. It is clear therefore that his assumption of office as Vice Mayor can in no way be considered a voluntary renunciation of his office as municipal councillor. In Lanzanita v. Commission on Elections, the court explained the concept of voluntary renunciation as follows. The 2nd sentence of the constitutional provision under scrutiny states, "Voluntary renunciation of office for any length of time shall not be considered as an interruption in the continuity of service for the full term for which he was elected." The clear intent of the framers of the Constitution to bar any attempt to circumvent the 3-term limit by a voluntary renunciation of office and at the same time respect the people's choice and grant their elected official full service of a term is evident in this provision. Voluntary renunciation of a term does not cancel the renounced term in the computation of the 3-term limit. Conversely, involuntary severance from office for any length of time short of the full term provided by law amounts to an interruption of continuity of service. Thus, respondent's assumption of office as Vice Mayor in January 2004 was an involuntary severance from his office as municipal councillor, resulting in an interruption in the service of his 2001 to 2004 term. It cannot be deemed to have been by reason of voluntary renunciation because it was by operation of law. Succession by law to a vacated government office is characteristically not voluntary since it involves the performance of a public duty by a government official, the non-performance of which exposes said official to possible administrative and criminal charges of dereliction of duty and neglect in the performance of public functions. It is therefore more compulsory and obligatory rather than voluntary. Borja v. Kumlik. Facts: Jose Capco, Jr. was elected vice mayor of Pateros on January 18, 1988 for a term ending June 30, 1992. On September 2, 1989, he became mayor, by operation of law, upon the death of the incumbent, Cesar Borja. On May 11, 1992, he ran and was elected mayor for a term of 3 years which ended on June 30, 1995. On May 8, 1995, he was re-elected mayor for another term of 3 years ending June 30, 1998. Jose Capco filed a certificate of candidacy for mayor of Pateros relative to the May 11, 1998 elections. Benjamin Borja, Jr., who was also a candidate for mayor, sought Capco's disqualification on the theory that the latter would have already served as mayor for 3 consecutive terms by June 30, 1998 and would therefore be ineligible to serve for another term after that. Kumlik ruled in favor of petitioner and declared Capco disqualified from running for re-election as mayor of Pateros. On motion, the Kumlik and Bank reversed the decision and declared Capco eligible to run for mayor. It ruled that Capco's succession into office is not counted as one term for purposes of the computation of the 3-term limitation under the Constitution and Local Government Code. Capco was voted for in the elections. He received 16,558 votes against petitioners' 7,773 votes and was proclaimed elected by the Municipal Board of Canvassers. Issue: 1. Capco is eligible to run for mayor held yes ratio. First, to prevent the establishment of political dynasties is not the only policy embodied in the constitutional provision in question. The other policy is that of enhancing the freedom of choice of the people. To consider, therefore, only stay in office regardless of how the official concerned came to that office, whether by election or by succession by operation of law, would be to disregard one of the purposes of the constitutional provision in question. Thus, a consideration of the historical background of Art. X. 8 of the Constitution reveals that the members of the Constitutional Commission were as much concerned with preserving the freedom of choice of the people as they were with preventing the monopolization of political power. Indeed, they rejected a proposal put forth by Commissioner Edmundo F. Garcia that after serving 3 consecutive terms or 9 years there should be no further re-election for local and legislative officials. Instead, they adopted the alternative proposal of Commissioner Christian Monsad that such officials be simply barred from running for the same position in the succeeding election following the expiration of the 3rd consecutive term. Monsad warned against pre-screening candidates whom the people will choose as a result of the proposed absolute disqualification. Considering that the draft constitution provision recognizing people's power, 2 ideas thus emerge from a consideration of the proceedings of the Constitutional Commission. The first is the notion of service of term, derived from the concern about the accumulation of power as a result of a prolonged stay in office. The second is the idea of election, derived from the concern that the right of the people to choose those whom they wish to govern them be preserved. It is likewise noteworthy that, in discussing term limits, the drafters of the Constitution did so on the assumption that the officials concerned were serving by reason of re-election. Indeed, a fundamental tenet of representative democracy is that the people should be allowed to choose whom they please to govern them. To bar the election of a local official because he has already served 3 terms, although the first as a result of succession by operation of law rather than election, would therefore be to violate this principle. Second, Not only historical examination but textual analysis as well supports the ruling of the Cumlic that Art. X. 8 contemplates service by local officials for 3 consecutive terms as a result of election. The first sentence speaks of the term of office of elective local officials and bars such official as from serving for more than 3 consecutive terms. The second sentence, in explaining when an elective local official may be deemed to have served his full term of office, states that voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. The term served must therefore be one for which was elected. The purpose of this provision is to prevent a circumvention of the limitation on the number of terms an elective official may serve. Conversely, if he is not serving a term for which he was elected because he is simply continuing the service of the official he succeeds, such official cannot be considered to have fully served the term notwithstanding his voluntary renunciation of office prior to its expiration. Reference is made to Commissioner Byrne's comment on Art. 6. 7, which similarly bars members of the House of Representatives from serving for more than 3 terms. Commissioner Byrne states that if one is elected representative to serve the unexpired term of another, that unexpired term, no matter how short, will be considered one term for the purpose of computing the number of successive terms allowed. This is actually based on the opinion expressed by Commissioner Delvey. Yes, because we speak of term and if there is a special election, he will serve only for the unexpired portion of that particular term plus 1 more term for the senator and 2 more terms for the members of the lower house. There is a difference, however, between the case of a vice mayor and that of a member of the House of Representatives who succeeds another who dies, resigns, becomes incapacitated, or is removed from office. The vice mayor succeeds to the mayorship by operation of law. On the other hand, the representative is elected to fill the vacancy. In a real sense, therefore, such representative serves a term for which he was elected. As the purpose of the constitutional provision is to limit the right to be elected and to serve in Congress, his service of the unexpired term is rightly counted as his first term, rather than refute what we believe to be the intendment of Art. X. 8 with regard to elective local officials, the case of a representative who succeeds another confirms the theory. Petitioner also cites Art. 7. 4 of the Constitution which provides for succession of the Vice President to the Presidency in case of vacancy in that office. This provision says that no person who has succeeded as President and has served as such for more than 4 years shall be qualified for election to the same office at any time. Petitioner contends that, by analogy, the Vice Mayor should likewise be considered to have served a full term as Mayor if he succeeds to the latter's office and serves for the remainder of the term. The framers of the Constitution included such a provision because, without it, the Vice President, who simply steps into the presidency by succession would be qualified to run for president even if he has occupied that office for more than 4 years. The absence of a similar provision in Art. X. 8 on elective local officials throws in bold relief the difference between the 2 cases. It underscores the constitutional intent to cover only the terms of office to which one may have been elected for purpose of the 3-term limit on local elective officials, disregarding for this purpose service by automatic succession. There is another reason why the Vice President who succeeds to the presidency and serves in that office for more than 4 years is ineligible for election as President. The Vice President is elected primarily to succeed the President in the event of the latter's death, permanent disability, removal, or resignation. While he may be appointed to the Cabinet, his becoming so is entirely dependent on the good graces of the President. In running for Vice President, he may thus be said to also seek the presidency. For their part, the electors likewise choose as Vice President the candidate who they think can fill the presidency in the event it becomes vacant. Hence, service in the presidency for more than 4 years may rightly be considered as service for a full term. This is not so in the case of the Vice Mayor. Under the Local Government Code, he is the presiding officer of the Sanggunian and he appoints all officials and employees of such local assembly. He has distinct powers and functions, succession to mayorship in the event of vacancy therein being only one of them. It cannot be said of him, as much as of the vice president in the event of a vacancy in the presidency, that in running for vice mayor, he also seeks the mayorship. His assumption of the mayorship in the event of vacancy is more a matter of chance than of design. Hence, his service in that office should not be counted in the application of any term limit. To recapitulate, the term limit for elective local officials must be taken to refer to the right to be elected as well as the right to serve in the same elective position. Consequently, it is not enough that an individual has served 3 consecutive terms in an elective local office, he must also have been elected to the same position for the same number of times before the disqualification can apply.